Well, hello everybody. Good afternoon. For those joining us for the first time today, we've had two good sessions this morning. This is our final webinar for today, the first day of the ICC Arbitration and ADR conference this year in 2024. So I'm delighted to introduce Costas Frangeskides. If I can introduce you onto the screen, Costas. That would be great. This is going to be, I think, quite a hot topic, given the conversation we had at the recent arbitration ADR committee meeting at ICC. These sort of issues generally get quite a lively audience. So we welcome your input. Please do use the chat room. The team will be in there, including myself, I have to say. And I will hand over to you, Costas, and then come in at the end. Over to you.
Thank you very much, Chris. Thank you indeed. It certainly is a hot topic. Before I make some introductory comments, may I introduce, I'm very pleased to introduce an excellent panel of practitioners with a vast amount of experience in this area. Let me introduce Kim Franklin, KC. She's a leading barrister in complex engineering and infrastructure disputes. Kim is also an experienced chartered arbitrator, acting as chair, party appointed, and sole arbitrator. She has lots of experience, vast experience in construction as a construction adjudicator and as the editor of Construction Law Journal. I do have to, Kim, mention a quote I saw on your LinkedIn profile, which says that Kim has everyone acting out of her hand. If there are two warring parties, Kim gets them to cooperate and calm down. So I like that. Then we have Rana Obeid. Rana is Associate General Counsel at Jacobs. She's a fellow of the Chartered Institute of Arbitrators and has huge experience in construction law in particular, in the Middle East, in this case for Jacobs, but also for other major contracting companies. Rana also worked in private practice before that. Next, James Clanchy, a commercial arbitrator, full-time arbitrator, associate member of Six Pump Court, member of the LMAA, and a full-time arbitrator since 2016, 30 years of arbitration experience. A former colleague as well of mine at HFW some years ago. But welcome to all of you, and there will be opportunities for asking questions at the end. But at that, I will pass over to James to commence with his presentation. Thank you, James.
Thank you, Costas. The ICC's Expedited Procedure provisions, the EPP, were introduced back in 2017 and are regarded as a great success. They are one of the major reforms that took place under the presidency of Alexei Moore. They respond to a demand for speed without urgency in commercial arbitration. It was, of course, a move towards emergency arbitrators, starting, I believe, with the Stockholm Chamber of Commerce around 12 years ago or so. But there has always been an appetite for a speedy resolution of a dispute without it necessarily being urgent in any objective way. What has been said about expedited procedures is that in many ways they take arbitration back to the basics, back to the resolution of a dispute outside court without the delays that the courts traditionally introduce. The ICC has always had an issue, shall we say, with speed. It's part of it, the way it works, that being international, needing to provide a neutral forum in quite complex disputes, time can be needed. But the EPP has proven to work extremely well for lower value cases in the ICC's term. So when it was introduced in 2017, there were some 15 EPP cases in that year. But the ICC has reported that last year it saw 189. The ICC has also reported that last year 39.5% of its new cases involved an amount in dispute not exceeding $3 million, which is the threshold for the EPP for disputes arising out of arbitration agreements concluded after the 1st of January 2021. So you can see that a large proportion of ICC cases could be caught by the EPP. And as we shall be discussing, while this does represent success for this new procedure, it also raises some issues, such as party autonomy in relation to the appointment of the tribunal. But the ICC does face a challenge in London-seated arbitrations in particular. What I have in mind is that whilst the EPP works extremely well in the international context and relative to the ICC's normal procedure, the ICC faces major competition in London from the traditional form of arbitration here, ad hoc arbitration under the Arbitration Act. I say this because the default procedure under the Arbitration Act is quite different from that under the anti-trial model law. It's basically much faster. So under section 16(5) of the Arbitration Act, a tribunal of 3 arbitrators should be formed within 2.5 weeks of the commencement of the arbitration. I say that because 16(5) requires that the respondent appoint their arbitrator within 14 days of the notice of arbitration, and then the 2 arbitrators so appointed are to appoint the 3rd forthwith. I'm not sure there's any precedent on that, but that's generally regarded as meaning a couple of days, basically. Now, for the tribunal to be appointed within 2.5 weeks is much, much faster than anything under ordinary institutional rules, and indeed much faster than under the anti-trial model law. It's one of the major reasons why London remains the world's favourite seat. And it's also a major reason why most international commercial arbitrations seated in London take place outside the institutions. I've been asked to say something about the LCIA's position on expedited procedures, bearing in mind that it doesn't have an equivalent of the EPP. And I think it's worth putting the LCIA in the context of ad hoc arbitration under the Act here, because I've referred to section 16(5) of the 96 Act, but going all the way back to the 1950 Act, the provision there was that the respondent's arbitrator in an ordinary default case had to be appointed within 7 clear days of the notice of arbitration. In other words, in London, arbitration was expected to be fast. You get going quickly. The LCA provided something different. It provided something more like the ICC, more like institutional arbitration in other places. The homegrown institution, the LCA, its USP in London was that it didn't go in for the rough and tumble of ad hoc arbitration. Instead, it provided a more considered approach, a more careful, one might say, but certainly a slower approach. Having said that, it also has no terms of reference. It has a default procedure for the exchange of submissions, which is relatively quick. So it doesn't have some of the issues that the ICC has faced in its ordinary procedure. And that, I think, is the main rationale for the LCA not having its own expedited procedure. Looking, though, at ad hoc arbitration in London, which is still, despite the efforts of the institutions, which have grown enormously in recent years, ad hoc arbitration remains more popular. I would just like to say a quick word about the London Maritime Arbitrators Association small claims procedure. The SCP sees actually roughly the same number of arbitrations a year as the ICC's EPP now, but it's for genuinely small claims, that is normally under $100,000. And it goes further insofar as there is no CMT, which I really do recommend as a step for expedited arbitration. Don't consult the parties. They will come up with different ideas. There's no time for that in a speedy procedure. So long as the parties have signed up in advance to a timetable, you shouldn't need to have that. So the small claims procedure is for an ad hoc arbitration. The fixed fee is paid direct to the arbitrator who is appointed, and then the timetable that is set out in the procedure is followed, and it usually results in an award within 4 or 5 months of the commencement of the arbitration. And I do recommend that as a procedure to have a look at. And I say that partly because the monthly trial expedited arbitration rules, which are meant for ad hoc proceedings, were actually largely based on institutional rules and are therefore rather slower. So we have in London this interesting diversity of ad hoc and institutional arbitration. And I think the institutions do have something to learn from disintermediated arbitration, as Sir Geoffrey Voss might call it. And I will rest my case there. Thank you.
Thank you very much, James. We will have an opportunity, as I said earlier, for the attendees to ask questions. But in the meantime, we'll move on to Kim.
Thank you. Thank you very much. And thank you, James, for putting things in context so neatly. So when these expedited procedures were introduced in 2017, they were for disputes up to $2 million US dollars. And that threshold was increased in 2021 to 3 million. Since when the ICC has administered over 700 EPP cases. About half of those go to a final award. And last year, the figure James quoted of 189 new EPP cases has set a new record. And because the EPP is considered to be such a great success, there is a working group now considering expanding scope to exceed the median value of ICC arbitrations in 2023 last year, which is a figure of $5.5 million US dollars. So they're looking at increasing the scope to exceed that value, which would then have the effect of encompassing half of the ICC cases. So with that in mind, it is worth asking ourselves, why are these procedures necessary? And if you read the reports about them, the recurring theme is that they've been introduced to address what's described as users' concerns. Users' concerns that international arbitration takes too long and costs too much. The parties, we are told, time and again, want quick and cheap dispute resolution. But I sit exclusively as a tribunal now, and I want to question that. I say, do they? Do they really? Let's look at these users who are coming before us, wanting quick and cheap resolution. We're told half of them, we know almost for sure, want to postpone the inevitable for as long as possible. And we can call that half the respondents. There's a surprising number of claimants, though, who actually don't want speedy resolution for a number of reasons. And I was at an ICC conference when this was put to the poll, and 25% of the claimants there accepted that they weren't particularly in a rush to get a result. And the reasons tend to be commercial. One is a very familiar one, which is, well, we started this claim as a negotiating tactic, and it's flushed out rather a nasty counterclaim, or otherwise it's backfired horribly. Another reason is that having a big claim on the books is commercially more valuable than a miserable award. It can be used, for example, to do clever things in the accounts or keep the banks at bay. And with the sort of construction disputes that I deal with all the time, they are very team heavy. There's a lot of people involved, and a big claim keeps that team quite busy, employed, until some real work turns up for them. And there are other reasons, and I'm sure you're familiar with them. But let's say, for argument's sake, that half of the parties want quick and cheap dispute resolution. Why, I ask, do they then proceed to agree these labyrinthine procedures that takes 3 months? 3 months to choose a chair, not to appoint a tribunal, but 3 months to get the chair chosen. And having got the tribunal appointed, why do they agree a year-long timetable for exchanging their statements of case? So this is just the pleadings, and then another year for their evidence. And why do they agree a documents disclosure process that crushes all in its path under the weight of the hundreds of pages of Redfern schedules? And if the tribunal comes up with the nifty idea of maybe defining the issues earlier on so that the parties can focus their preparation on the issues and limit their documents and their factual evidence and their expert evidence to the matters that are actually an issue that the tribunal needs to decide rather, why, when the tribunal suggests that that's done as early as possible in the proceedings, do the parties agree to push it right back as far as possible, perhaps 10 days before the hearing, sometimes even 10 days after the hearing? And from the tribunal's point of view, if the parties agree these long and burdensome timetables, if they agree them, there's very little the tribunal can do about it. And speaking from experience, attempts to shave off the odd week here and there are met with howls of protest, allegations of tribunal aggression, and stern reminders that this is not an EPP. So I ask, well, look, why not? If you really want speedy resolution, you can have it. You're having these extended procedures because you choose to. Now, you'll be familiar with the EPP procedures, which require a sole arbitrator to give an award within 6 months of the CMC. And that's quite a stark comparison to the timetable I've just described, where they take 2 years to prepare the evidence. I sit as a UK construction adjudicator, which requires a decision to be given within 28 days. That is 28 days after referral. Now, that can be extended by 2 weeks by the referring party or longer by agreement. And although it was originally intended for relatively low value on-site payment disputes, it is now used for any type of dispute, a construction dispute, that can be referred to adjudication at any time. And it's increasingly used for high-value, complex disputes long after project completion. An adjudicator's decision is temporarily binding. It can be revisited in court or arbitration, but most parties accept the decision. And for these really vast and unmanageable disputes, adjudication is used to identify particular issues, isolated issues, which can be referred as part of a series of adjudications to unlock a wider dispute resolution strategy. It's usually conducted on a documents-only basis. The adjudicator can interrogate those documents, or the parties, if they want to, at a meeting, increasingly rarely, or in writing. Expert procedures can be incorporated. And of course, the referring party has all the time in the world to prepare its claim in the first place. Importantly, there is no provision to recover costs. So that tends to have a limiting effect on the expense. So against that background, you can see that 6 months for an expedited procedure is a bit of a luxury. And remember, that's 6 months from the CMC, not 6 months from kickoff. I did one of the first EPPs in 2016, and there we found on a practical basis, the main challenge was finding a time when everyone was available for a hearing. And inevitably, that was right up towards the back end of the 6-month period. The arbitrator had to be allowed time to write their award, and the ICC needed time to scrutinize it. So it meant that preparation time was relatively generous, and the real action was condensed right at the end. But from my experience of EPPs and construction adjudication, expedited procedure requires a sensible, workable timetable, and you have to get that clear right at the beginning. It's no use leaving it all open to negotiation subsequently. Everyone knows what they have to do, and then to be able to devote the resources to do it, and they have to know that from the outset. And then the parties have to be reasonably sensible about this. They have to adhere to that timetable. There is just no scope for playing games. And the whole process has to be managed by an experienced tribunal who knows what keeps their eye on the main objective. You know, a bit like conquering Everest, you're not supposed to enjoy the journey, you're just supposed to get there. And you need a seasoned explorer in order to ensure that that happens. So I would say there's absolutely no reason why disputes can't be decided quickly and cheaply. Everyone wants it. They tell us, these users tell us, of course they do. And any claimant in their right mind would agree. They've just got one caveat. They've just got one little point, which is so long as it goes their way. And the idea that they might not succeed seems to shift the dial completely the other way. And then suddenly they want chapter and verse on everything. They want to keep all their options open for as long as possible. They want to argue every point. They want to keep their experts on the leash. They want to agree nothing and have the last word. So the thing is, you can't guarantee results in dispute resolution. I mean, it's a fact, 50% of lawyers lose their case. It's a fact. And cast iron cases don't really exist. One of the first things I learned as a junior barrister was even a cast iron case only has a 70% chance of success. So bearing in mind that there is a risk that you may not win, you can devote all this time and resources and still end up with an answer that you don't want. So why not do the sensible thing and opt for a more expedited approach? Save your resources for doing what you do best, getting out there and earning money. And if you insist on having these very protracted and burdensome timetables, please don't complain that arbitration takes too long and costs too much money. Thank you.
Thank you very much, Kim. Very interesting. Now turning to Rana.
Yeah, thanks. I will maybe start off from where Kim ended. Is it really more expensive and more what is more expensive, going to other forms of dispute resolution, really? Because we've seen from in-house lawyers' perspective that sometimes the traditional dispute resolution and going to courts would really be much more expensive due to the sometimes the court not being very much familiar with the dispute. At least we will have the ability to choose the right arbitrator in this case if we opt for international arbitration administered under tested rules. So from an in-house construction lawyer perspective, really, we do struggle. I work for an international corporation where our major projects are with government clients, and they are heavily influenced by the higher government authorities. The way we see the main big these days giga projects, but in particular in Saudi, the dispute resolution is structured in a way that it complicates for either party to really go into any dispute process, and this will really apply as well and complicate matters for the supply chain. There is a perception here that the dispute resolution provision under the main contract more or less should be mirrored in the supply chain dispute resolution provisions. In the Middle East, we have seen a huge tendency to go to local courts, and my concern usually is the historical perception of the influence and the potentially biased dispute, outcomes. And on the other side, the perception of a more expensive process for what could be lower value projects. So we try to balance it. We have seen some giga projects here recently going to a very expanded dispute resolution provision where in very few cases the EPPs were introduced and opted for explicitly in the contract. Otherwise, the market actually is tending to follow the best international arbitration practices, but through locally newly registered arbitration centers. We as an international contractor have really introduced the ICC arbitration procedures in our standard forms, trying to promote the best practices. Yet we have concerns in relation to the technical aspects of projects and disputes, where we find here a tendency to a large extent to engage experts, engineering, technical, specialized matters of different nature, which could be problematic under the EPP provisions. The way we tackle this is through tailoring our dispute resolution provisions, particularly to allow for more parties' autonomy in this case at an early
We might have lost Rana. So while hopefully wait a few seconds. Okay, well, I'm sure we'll hopefully get Rana back and she can join as soon as the IT issues are resolved. It was a shame because she was leading into a question I was about to ask, which related to the fact that here we're really talking about what users need, and Kim mentioned it earlier. So looking at it from the perspective of a user of arbitration, international arbitration, and is it fit for purpose? And what I often find, and I'm sure panelists often find, is in a dispute, you have one of the parties say, well, I'm not sure why we put that clause in. Did we ever think about it? So for litigators and arbitration specialists, it's always maybe not a surprise that the clients say, well, might not use that again. So my question really was, and hopefully Rana will join us again in a bit, to Kim and James, is what should users of arbitration, what should they be thinking about when they include a clause in the contract at the outset? What are the important points? So a user isn't probably that familiar with each type of institutional clause, ad hoc, etc. They may not be as sophisticated, understandably. But what would you say to somebody who's got a raft of institutional rules to choose from, and what are the important points?
Well, as far as expedited procedures are concerned, they should have in mind when signing off on a contract what sorts of disputes might arise. It's often difficult to look forward in that way. But an ordinary ICC arbitration or other institutional arbitration may simply be too expensive, too cumbersome for a dispute about an unpaid invoice. They should consider having particular provisions in their dispute resolution clauses for smaller claims. And there are possibilities for mixing and matching. You can perfectly well submit smaller claims to a different regime, to a different institution. In shipping contracts, I've certainly seen plenty of clauses, indeed standard form clauses, in which the main dispute resolution clause simply provides in the old-fashioned way for arbitration before a tribunal of 3 in London without specifying the rules. So ad hoc arbitration, London. But then subsection B will say, for a claim not exceeding $100,000, the LMAA small claims procedure will apply.
Hi, Rana. Good to have you back.
Hi, apologies. I had
No
some
problem at all.
technical issues. I'm so sorry.
No problem at all. I took the opportunity to ask a question about effectively what you were talking about as to the nature of the clause. What sort of clause should you be putting into a contract from the outset? What sort of arbitration clause? What sort of EPP procedure? So I was just asking generally. I don't know if you want to continue finishing your presentation.
That's fine. I will let James continue, and I'll jump in.
Okay. Well, good to have you back.
Thanks.
When I finished, really, I was just positing the option of having dispute resolution clauses which made provision for smaller claims, and therefore for expedited procedures, which could include, as I was saying earlier, could include very strict timetables and proceedings without hearings, without even case management conferences. The parties are perfectly capable of agreeing in advance in their contract that if they've got a smaller claim under a particular threshold, that's the route they will go down. And it's I do think it's worth bearing that in mind when deciding on dispute resolution clauses.
Okay. I mean, the interesting thing here, Rana, is it follows on from what you were saying, is I often find that when there's a dispute, the parties say, well, why did we include ICC? Why was it LCIA? Why was it LMAA? Without having given it much thought. And obviously you do, and you've just explained the sort of criteria. But we're thinking of users. I mean, what are the important points for you, Rana, when you're looking at negotiating an expedited provision or an arbitration clause generally?
Generally, first, the experience of and the background and the variety of the arbitrators and the support provided by the institution, then and the quality check and providing more comfort in enforcement. So and ensuring neutral proceeding is followed. So there are a bunch of points which would be discussed at each and every case based on the nature of the dispute, based on the nature of the services, based on the term of the contract and what would make sense or not. But our issue usually is in the supply chain and because the ultimate contract, the prime contract with the employer, would generally mandate either local courts or the local arbitration centers, which in my opinion, they're not well tested so far. They are young. They have good set of rules. They sit somewhere in between. Like, for example, the EPPs. We have the Saudi Commercial Center of Arbitration introduce around 4 million Saudi riyals, around $1 million threshold for expedited procedures, while the DIAT in Dubai has 1 million dirhams, that's around 272. So the Saudi center sits somewhere in between the Dubai International Arbitration and the ICC. We believe those thresholds are a little bit low, kind of. I think the ICC is more or less in the range, the reasonable range for low value disputes to go through this process. Yet we need to, usually the way we ensure that we allow joinders, we have to mirror the original dispute resolution provision throughout the supply chain if there's a joinder required. But if it's not a flow down dispute from the prime contract, we opt for the ICC in our standard forms of contracts.
So that's interesting. So if you adopt the ICC standard form, of course, the default position, if you put an ICC arbitration clause, is that the EPP automatically applies, expedited procedures apply in the way we've been discussing. Yeah. From a user, an in-house counsel, I mean, is that something that's good? Because there's a big debate about opt-out versus opt-in. And again, often clients or parties aren't aware that they are actually automatically within this procedure, albeit for lower value claims.
It could be, there are pros and cons. It could work either way based on whether we are the prime, whether we're acting on behalf of a prime or a sub. From a construction industry perspective, our main concern would be actually two things: the professional performance and payments and collections. When it comes to professional performance, we have seen that very often we would require third-party expert involvement, which in this case, we would prefer to opt out from the expedited procedures. But if it's a matter of collection and flow down procedures, and billing and invoicing, where the type of services are kind of pre-approved and then you invoice and go for collection, then, or it's time and material for our consultancy type of services. So this means that you are billing your personnel deployed on the project on pre-agreed rates for the deployment duration. So a matter of professional disputes would be less in this case. Then we would encourage leaving in and not opting out from the EPP.
Can I, thank you. Can I ask Kim that something you mentioned earlier, which flows from this, is your experience having been an arbitrator on EPP procedures. You mentioned that effectively it's up to the parties. If they want a long drawn out procedure for tactical reasons, well, that's what they're going to get. And it's going to be costly and not very quick. But in the EPP procedures you've seen, what is the reaction have you seen, if you can mention it, from parties? How have they found the procedures? Have they been pleasantly surprised? Do you have any sort of reaction on that?
Well, my award wasn't challenged, so I'm assuming the result was satisfactory. I think you will find that for construction disputes, where adjudication has been around for 25 years now, so the parties have got used to having what was perceived as really quite an unworkable procedure foisted upon them, and they spent quite a while fighting tooth and nail to overturn it and adapt it and challenge it at every opportunity, and then they settled down and started using it, and now they've become quite sophisticated in the way that they use it, and it's the go-to first port of call for dispute resolution for most construction disputes, even really very sizable ones. As one solicitor put it to me, I say to my clients, well, you can spend 100,000 on an adjudication and you'll get an answer that might be workable for the next stage, or you can spend $1 million on an arbitration and you might get an answer that's workable for you for the next stage. So, you know, where's your choice going to fall? So I think it is, I haven't had experience where one party's been prepared to get on with it and the other party really hasn't. Both sides have to buy into it. And because the EPP allows for a hearing of a traditional sort in person with cross-examination, if that's what you want, then it does tend to satisfy that need to be heard. That one of the objections is that well, we're going to be denied our right, we're going to be denied we're not going to have an opportunity to have a full say. Well, I think a hearing does tend to sort of satisfy that gladiatorial need to see your combatants go into battle and say their piece, and then the tribunal can base their decision on the documents, which they usually do, on the evidence, on the expert evidence, but they can also flavour it with the fact that they've seen the witnesses in person, and that tends to satisfy the parties as well.
Okay. The other question I had was in relation to the EPP procedure. Maybe James, you can chip in here. If a party believes its claim, it falls within the EP procedure, it's a lower value claim, but it's quite a complex claim. So for an individual, an in-house counsel, $4 million or $3 million is still, it may be significant. They may have a volume of these type of claims. Now, what if a party felt that it was a complex issue? It's a low value claim. I've fallen into this EPP procedure. I can see the benefit of it, but I want to have experts. I want to have witnesses. I want to have lists of issues. I'd like to have a pre-trial, a case management conference. How would you as an arbitrator deal with that sort of party who's pushing back?
Oh,
Albeit obviously the rules are in place, but how do you deal with that sort of party?
I'd say you can have it. You can have it all. It's just got to be done rather quickly. Have you got your experts lined up? Have you instructed them? Do they know what it is you're arguing about? Have a fortnight to put your report in. I mean, that's what they have to do in adjudication. There's no time to hang around. And of course, you know, there is another myth that this dispute has just sort of appeared out of the ether and nobody knew anything about it until it turned up on the arbitrator's desk. It's probably been running for some time. So the parties are fairly familiar with what it is that they need to have decided. It's amazing what people can do if they put their mind to it, in my experience.
James, any views on your side?
Yes. I think it's worth looking at the other side of the coin, actually, if I could, which is that sometimes when there is a complex dispute, and as Kim says, that the parties have already been in exchanges, they've probably tried to settle it already before they've had to commence any proceedings. But quite often, in my experience, they want a decision, they want a quick decision. They recognize there are complexities there, but they don't necessarily want to trouble the tribunal with all of it. They don't necessarily want to appoint new experts and go through instructing them and obtaining new reports on the facts that they've already been talking about with each other. I mean, I've had recent experience in small claims procedures of this kind of situation where there were situations which were actually and or legally complex, but the parties were restricted in the length of their submissions. They weren't allowed to have expert reports, and that's actually what they wanted. They wanted to be able to have their say in writing within a few weeks, and then leave it to the arbitrator to decide, and then their dispute would be over. That's what they wanted. Of course, there'll be parties who want to go into all the complexities, want to have hearings, want to have their witnesses. There are plenty of commercial parties who just don't. So it works both ways.
How do you deal with this impression often that comes along, which is that arbitrators are so concerned about their awards being challenged that they will bend to further requests for time extensions and further document requests?
Well,
and that presumably is a benefit of the EPP procedure.
I think it's so important that you should have rules, and the EPP goes some way towards that, which just don't give room for that kind of thing, and indeed for guerrilla tactics. As I said in my presentation, one of the great virtues of the LMAA small claims procedure is that there's no CMC. The parties are not given an opportunity to shape the procedure, as we say in international arbitration. The procedure's been shaped in advance, they've signed up to it. That means that the arbitrator shouldn't have concerns about due process. Process is set in concrete in advance.
Thank you, James. I've got some questions from the attendees. If a party is trying to delay, I think it's following on from what we're talking about, trying to delay things, present obstacles, do you consider the expedited procedures are still suitable? And I think it follows from what we just said that it is. it can stop
Yes.
that. Now, maybe a question for Rana that's come in. Because you're in the Middle East, I'm just thinking about different regions. I think you touched upon this. These sort of rule changes, there are reforms now. Are they perceived differently in different regions? In your experience, in your area?
Yeah, I would be very frank to say that there need to be some kind of education. We are really somehow lagging behind as to the use of the procedures and benefiting from the procedures because of the sovereignty around the dispute resolution, I would say, process, always wanting to go to local courts or local available institutions, and this contributes to lots of delays and lots of challenges and issues in enforcement. I believe that the thresholds as amended would be very practical in the industry I am working in. Hence, we see more of the local rules trying to follow that. Right?
Okay, and that's leading into a good point, which is whether or not we should be lifting the thresholds in expedited procedures. At the moment, the ICC threshold is $3 million. And they're looking, I believe, without revealing any secrets, I think it's pretty clear that most of the working groups are looking at whether they should increase those thresholds. I don't know, Kim, if you want to comment on whether they should be and how far they should be increased.
Well, I'd be in favor of it being an option for anyone if they wanted it. The question is whether it's going to be required of the parties to sign up to it, and I think it's very difficult to. I was interested to hear that the median figure for last year's ICC arbitrations was $5.5 million US, which seems sort of claims that I deal with. That seems really rather small. And given that the whole ICC structure is structured around the value of the dispute, it makes perfect sense to me that 2 million, 3 million, 5 million, 6 million, whatever, you know, that can only enhance the process. Whether when you get to the 10 million and the 20 million, and dollar disputes, it probably would be less welcome, or a lot more education, as Rana says, would be required to make that acceptable. But I think it's just spreading the word, really. You've got to ask yourself, how do you want to spend your money? And we haven't talked obviously about mediation because it's not really our topic, but there's another way to get your dispute resolved pretty quickly. It's to not have a dispute and then get on and get on with your commercial activities, and then use your resources to that effect. So I think if there's the general encouragement to think whatever it is, you want to get over this dispute and move on, and no amount of resources is going to make it any better result, really, truth be known. So let's try and deal with it as efficiently as possible.
So if we look at it from the perspective, we're obviously talking about expedited procedures, but say we've got an in-house counsel listening to this, watching this and thinking, oh dear, I've got a $20 million dispute. I'm outside of it. I can opt in under the ICC procedures, but my opponent is a complete nightmare. He's what Kim has described, the recalcitrant party who doesn't really want to take much part and make sure things go slowly. In that scenario, James, from your experience, and I'm looking at the LCIA, which doesn't have expedited procedures, what could an arbitrator do, or a panel of arbitrators, to try and stymie that, say it's ICC or LCIA?
Well, the tribunal will have a general duty to conduct the proceedings in a fair manner, and it will feel obliged to reach an award as soon as it can, practicably. So it will always be careful to avoid being forced by one party to delay matters. The fact is that, yes, under the LCA rules, for example, and under other institutional rules, the tribunal will generally have powers to deal with proceedings expeditiously. There are ways and means that it can exercise those powers. It's obviously a good idea for parties when they're selecting arbitrators to have their genuine availability in mind, and any reputation that they might have for speed. I think there's enough flexibility built into the LCA rules, and indeed into the ICC rules, to ensure that the proceedings in the normal courts can be expedited.
Yeah,
but there's no doubt that one of the advantages of small claims procedures of the kind that I've described is that you simply don't have, the parties don't have the parameters within which they can slow things down. So, for example, you might allow one extension of time of 14 days, and that's it. After that, bad luck. If the parties have signed up to that sort of procedure in advance, then things are bound to go more quickly and more predictably as well. You will know that there will be a deadline of whatever it might be, 6 months from the commencement for the award finally to be.
I'm just looking at thank you, James. Just looking at some other questions. There's one regarding SMEs, small enterprises, small and medium enterprises. They really appreciate something like this, a fast track adjudication, would welcome expedited arbitration, but the final and binding nature, I think that nature arbitration could deter them. I think they mean that it's not an adjudication so much, it's more final binding award you're stuck with. I mean, what would you say to somebody who owns a business who's looking for expedited procedures in relation to their lower value claims?
Well, actually, this question fits in quite nicely, doesn't it, with your comment that the ICC might be looking to increase the threshold. I think for a lot of companies, particularly for SMEs, the current threshold of $3 million is actually very high. That might be one of their biggest ever claims. And in those circumstances, for them to learn that they're not going to be able to appoint their own arbitrator, and it might just go to a sole arbitrator, that can be a bit of an issue. But at the same time, indeed, having a reasoned, enforceable award at the end of a relatively quick process, that has to be attractive to the more limited.
Thank you. We've got a few minutes to go, and I thought I'd just pose the final question, which is, there are a number of working groups under trial ICC working on reforms, but I think, are they fit for purpose? Just a short answer from each of you at the moment. Are these procedures fit for purpose at the moment?
The anti-trial expedited arbitration rules are not fit for purpose, and I think it's a great shame that they were published without more consultation amongst those involved in ad hoc arbitration. I think the ICC and other institutional expedited rules are doing a great job, and they're certainly promoting debate.
Yes, I think the ICC rules are a great success, and really it ultimately comes down to the parties. It doesn't matter what procedure you've got. If someone's determined to be uncooperative and troublesome throughout, it's always going to be difficult. The way to make these procedures really work is for the various industries and the SMEs to get hold of them and then adapt them by agreement and by experience to suit their own purposes and use them regularly and make them a thing.
Yeah, and it is on-house counsels really to get a better understanding from the business of potential disputes and advise accordingly. I believe that it's very important to look at the provisions and the details of the EPPs on case-by-case basis and make the best of them. If need be, tailor and opt out with respect to certain provisions. And this, I believe, is the best way, and to just make sure that it serves the purpose.
Okay, well, thank you. I can see Chris online now. I should thank you all for being on the panel. I'll hand over to Chris, and thank you also for all the questions that have come in.
Thanks, Costas, and special thanks to you and all the panel speakers today. That's been a really interesting conversation. I take the final point away that the ICC rules are a great success and doing quite well, I think, from my takeaway from this panel's discussion. But massive thanks to everybody who's participated today. This is the conclusion of day one of this year's arbitration and ADR conference at ICC. Massive thanks to the sponsors, EY, Simmons & Simmons, 39 Essex Chambers, Jazz Mundi, Trailview, and Latham & Watkins. For all those coming to us tomorrow for the face-to-face day, please don't forget Simmons & Simmons, City Point, 1 Roadmaker Street. We'll see you there at 9 o'clock in the morning for registrations. The team will be there at about 8:30, if not before. So please do come early and look forward to carrying on the conversation in person tomorrow. Thanks so much, everybody. Look forward to seeing you all in the morning.
Take care.
Thank you. Thanks, everyone.